Good evening, everybody, and thank you so much for making time to be part of this conversation where we seek to understand more about the Competition Authority of Kenya and, of course, the work that they do within how to identify, how they investigate, how they prosecute, and, of course, how they put together systems and tools to deter cartels, to protect Kenyan consumers, and, of course, the Kenyan economy. My name is Teriana. I am a communications practitioner. I am a strategy lead and business development lead at CNBC Africa here in Nairobi. And I'm really looking forward to this conversation, both with my background and my ears as a journalist, but also as a Kenyan who has, of course, heard a lot about cartels, what they are, and with my mind as a business journalist, the effects and the impact of cartels to our economies. Before we get into it, Eric, perhaps just tell us a little bit about Mwango and why you specifically thought this topic or this conversation is important for today.
Yes, thank you so much, Terian, for agreeing to be a host. I know you're a very busy person, so thank you for being with us today. So yes, my name is Eric Mokai. I'm the founder. We really like to have topical issues discussed here on Mwango Spaces. And even though tomorrow is all about the budget, we want to take a little bit of a break from that to discuss a little bit on what cartels are all about. So we have two able speakers here who are going to explain what they are and why the CAK is there as a regulator to try and make sure that these things are in order all the time in the markets. I will not preempt what the speakers are going to talk about, but I think this is a topical issue. The political sphere, people hear a lot of the word cartels and they have a different meaning over there. So we want to get the business space and get to understand what that is all about. So back to you, Terian, so you can continue with the conversation.
Thank you so much. And you're so right. In the Kenyan context, cartel could mean one thing or the other depending on the circles that you're in. But now that we're here with the Competition Authority of Kenya, let's get the true definition of a cartel. But I guess before we get into it, Mogambi Mutegi is here with us, who's in charge of communication corporate affairs at the Competition Authority of Kenya. Perhaps introduce us to the Competition Authority of Kenya, what you do, and then a segue into our conversation for this evening.
Thank you, Terian. Thank you, Eric. I'm Mogambi Motegi. I'm in charge of communications at the CAK, the Competition Authority of Kenya. Essentially, what the CAK does is try to ensure that competition in our market, in our economic markets, in our various sectors as we know them, is effective, that consumers, you and I, benefit from that through access to competitively priced goods and services, not necessarily cheap, but at a level which we know is influenced solely by the forces of demand and supply, that we access commodities that are innovative. Where there's no competition, people don't innovate. There's no motivation to do that. As a government agency, we do this through various departments or core technical units. We have mergers and acquisitions. This is, as the name suggests, we ensure that when two companies are coming together, two or more companies want to merge for whatever reason, it could be efficiencies, they have to come to us first to assess how it will impact the market in terms of numbers, in terms of how many companies in that sector will remain, will competition be effective, and also how it's going to impact you and I as a consumer, if at all, public interest concern, how is it going to impact the economy, SMEs that are playing in that space. Then we go to buyer power. Buyer power, we've been in the news quite a bit of late regarding our enforcement actions across the country. So buyer power is basically where, as it described now in the law, the Competition Act, is where you have two entities, a buyer and a supplier, with the buyer being the person in the upstream who has access to an asset, an infrastructure that the guy below them who is supplying goods to them or services is highly dependent on. So this is in every sector where there's a bit of bargaining going on. The person with the higher bargaining power may abuse that, so we sanction against that. There's a very critical task or function that we do, consumer protection. We ensure that are not misled in the markets, that the goods that you consume do not harm you. If they harm you, what do? That the players out here making various commodities for us play by the rule book. If there are standards applicable, they follow them. If they fail to do it, so we can come for them. There are various forms of egregious conduct that constitute consumer welfare infringements. So that is number 3. Then anti-competitive conduct, which in the competition world also is called restrictive trade practices, RTP, is what now we are concerned with today. Here we are talking about anything that's done in the market by someone to restrict or reduce competition is anti-competitive. So you'll find price fixing, abuse of dominance, Again, a very topical subject. You'll find market allocation. So abuse of dominance, obviously 50+% market share. We may abuse that position. Things like market allocation is where there are many people in a market. Then we say you'll be in this county, region, and I won't bother you on this other side. Again, it's a cartel. Price fixing, as I earlier mentioned, even two players just come and say there's no need of us competing. Actually, though, competing is very expensive. You have to invest in research and development, go to the market, test new products, see what people want, then come back. So it's more from a business perspective, someone who is thinking about joining a cartel, it's a very efficient way of doing business. Sitting down with your competitor and deciding, you know what, let's not compete. Let's just agree. Base is should get below 50 bob for this. Yeah, things like that. Priska will describe with more detail what cartel is, but cartel sits within anti-competitive practices, which is, again, one of the 4 core activities or functions the CAK has.
As you spoke, Gambi, I had so many instances and industries and names of companies which I cannot mention and you cannot mention as well, that over the years we have seen them get into anti-competitive behavior and that have been in the news actually for a while. We do see the work that the Competitions Authority is doing and the impact that some of the deterrence and the investigations that are ongoing or that have been done in the past has had on the economy. So thank you so much, Mugambi. And of course, I know you will be with us throughout this evening and you will also be answering some of the questions that come through directly on Twitter. So to our audience, please, if you do have any questions, comments as we go along, please add those or tweet them. And we have the team from CAK who will be answering them live and hopefully also at the end, if time agrees, we will also be able to have a one-on-one. So I'd like to now welcome Priska Mwanyale, who's joining us from the Competition Authority of Kenya. Priska is an investigator, but I'd like her to introduce herself first. Before we get into the conversation. Priska, good evening, and thank you so much for making time to be with us on Mwango Spaces this evening. Please introduce yourself to us and tell us a little bit about what to expect this evening.
And good evening. My name is Priska Mwanyale, and I work at the Competition Authority of Kenya as a senior investigation officer. By way of background, I'm a lawyer and an economist by training, and my day-to-day work involves uncovering cartels. So typically would be examining markets and examining tender documents to see whether they show certain tendencies of bid rigging, for instance, or I'll be looking at agreements that depict price fixing. I'll be looking at whether there's instances in the market that depict to unusual shortages of product due to output restriction or market allocation. Today, I'm happy to share the over 8 years experience that I've gained through my work at the Competition Authority, and I hope the audience will enjoy it and learn more.
Thank you so much, Priska. So as we kick off, and as we mentioned initially, Mokaya and myself, and even Mugambi, that cartels could mean one thing or another. Sometimes we take it too lightly. It has been redefined and Kenyanized in so many ways. Perhaps you can just tell us, what is a cartel? How are they formed within the Kenyan context from a CAK perspective? And why should we as Kenyans care about this?
Yes, good questions. Cartels are typically a collection of independent business entities or organizations who come together to agree to manipulate or to eliminate effective competition. So you'll find maybe there's XYZ companies who ordinarily should be competitors and should be making independent decisions, but they come with the sole goal of defeating competition. And by doing that, they enter into agreements, price-fixing agreements. They could be agreements relating to territorial allocations or agreements to do with output restrictions. For example, Company X and Company Y could agree of pricing a certain product that they both sell at maybe 1 shilling, 2 shillings, 3 shillings. And by that, they're able to defeat competition. Cartel, as we know it within the competition circles, it's basically a group of independent businesses that come together to manipulate effective competition.
Thank you so much. And why should we care? For myself, as a Kenyan, as a consumer, as somebody who buys product in a supermarket, maybe, I don't want to mention the product because then it might look like I'm putting it under the lens of CAK, but a regular product that I would buy in a supermarket. Why should I care? And how would I know as a consumer that perhaps this is under the cartels?
Okay, so when companies fail to compete or eliminate competition, then obviously there's aspect of price increments. From our investigations, we've seen that whenever there's a cartel, the price markup is about 20 to 35% inflation of prices. So that takes away money from consumers' money, which they would use in other activities. Other than that, there's a lack of innovation, for instance, because there's no need of competing. So they're not, competitors would basically not innovate and will just be producing the same products with no form of innovation because the competition lacks, and they've already agreed anyway. So why should they invest money in competition? Other than that, then there's also lack of choice. So the consumer also lacks choice and is just given a set of products. So for those reasons, then there's a need for consumer to be worried when competition is eliminated.
All right, Priska, tell us, how do regulators like the CAK uncover this shady deals? And you've talked about it as consumers. Now there are ways that we can now begin to see how prices are going, how the cartels are affecting the market. But how do you as a regulator uncover these deals? And what are some of the telltale signs that you see that we can also begin to see as consumers?
So cartels operate in utmost secrecy. It is very difficult, Tyrian, to uncover a cartel. And most of the times, even in other jurisdictions, you'll find that a cartel is uncovered 5 to 10 years after when the initial agreement was entered into. And because they operate in utmost secrecy, then the authority needs to constantly innovate and come up with strategies in order to uncover cartels. And some of the strategies that we use is what we call the informant reward scheme. So the informant reward scheme is a scheme that we came up in place whereby we tell members of the public, if you know of a cartel or if you're an employee of a certain organization and you've seen certain tendencies that are happening within that organization, then you can approach the authority using the informant reward scheme. Give us credible information that will enable us to uncover that cartel, and for that, then we reward you for the information that you provide to the authority. The other strategy that we use is what we call the leniency program. And the leniency program is a program whereby the members of the cartel themselves are accorded an opportunity to come and confess their sins in court to the authority. So if I'm a cartel member and for one reason or another, I don't want to be in that cartel anymore, or the high probability of being caught, then there's a mechanism through the leniency program where you can approach the authority and give the authority the information, and the authority will give you amnesty in terms of waiving up to 100% of the penalty that the others would have suffered if the investigation would have occurred. Other than that, we invest in a state-of-art investigations tool. Terian, we are in the process of upgrading our forensic lab and getting the best of the tools and gadgets, and when training our employees, staff, and our colleagues on the best methods of investigation and forensic analysis. We do market inquiries from time to time, and these market inquiries also inform the authority of certain characteristics and tendencies that might be happening within the market. Other than that, we also get tips from consumer bodies, from government entities, and even from some of the telltale signs that ordinarily would inform an investigator that a certain market is experiencing cartel tendencies would be perhaps unexplained price increments. Without any reason, there's no government intervention, there's no taxes, there's nothing, and we are seeing some unexplained price increments, or we see price uniformity despite the companies being of a different scale of production, or we see the similarity in which they release price revision, it's revised around the same time, or there's a tendency where perhaps the market leader comes in and makes an announcement, then followed by the rest of the companies coming in to implement this seemingly public announcement. Unexplained product shortages, for instance, is an indicator of market conduct, or a particular pattern in which government tenders or tenders by private are being won by a certain group of companies.
As you spoke, a few industries came to mind, and maybe not industries, sectors, or products. So my home is, I think, one of the biggest consumers of eggs. And I keep thinking there must be something going on. We were buying a tray of eggs at about 280 to 300 in 2020. Now we're buying a tray of eggs at about 650. Today, I just had a conversation with somebody about flight tickets over the last couple of years, and now like a business class ticket to the US or Europe. A return ticket from Nairobi is in cash terms about 650,000 and above. And we were like, these are cartels. So I know you might not be able to tell us in exact terms the specifics, but I'm just curious about how you choose which industries to investigate. Is it at random? And at the same time, are there sectors that are more prone to cartels?
Yes, Torian, there are sectors that are more prone to cartel, and this is through economic analysis and evidences that have been shown over time. Sectors that have few players, oligopolistic markets. We have 5 to 6 players within that market or less than that. Then these are sectors that are more likely to depict cartel tendencies. Other than that, sectors that produce homogeneous products, because if we are selling water, then it is water, right? Water is water. An egg is an egg, right? So it's a homogeneous product. Even those, they are more likely or prone to engage in cartel tendencies. Sectors where there's high level of investments and barriers to entry. For instance, say a sector where the initial capital is very intensive. Then also because of the barriers to entries, then it means only few players can participate in that particular market. Then those sectors also, from experience and what we've seen in our jurisdiction and other jurisdictions, is that those sectors are likely to depict cartel tendencies. Sectors where there's excess capacity on the supply side, there is also a tendency of them also trying to do market output restrictions so that they limit the amount of products that are being produced, and because of that they distort the laws of demand and supply. So we've also seen where there's an industry association, for instance, right? And because of this cordial nature of members meeting constantly in an industry association and knowing each other, then they may want to engage in cartel conduct. And whereby the few members of a product have very high market share, such that when their combined market share is above those of dominance, then those sectors, we've seen that they're likely to depict cartel conduct. So in terms of how the authority determines which sector to investigate, one, it's usually directed by the government agenda of the day. For example, if the government has an agenda on affordable housing, for instance, or something to do with health, affordable healthcare, then it makes sense for the authority to align its investigation towards screening those particular sectors. So we'll ordinarily screen, if it's affordable housing, then we'll be looking at the value chain. We'll be looking at the manufacturers of product, or cement or steel or paint, anything within the value chain that relates to affordable housing will be screened to ensure that they are complying with that. It doesn't mean that we necessarily need to find them to have contravened, but they will form part of the priority sector. Other than that, we also look at sectors that have high impact to public interest. So for example, if Kenyans love eggs or they love eating a certain product, then that is the product that the authority would consider channeling its resources in it because of the level of impact that is likely to accrue to the general public. Other than that, we have the random ones whereby consumers come to the authority to complain. Those will be the random investigations that will be taken in along the period of time, or when we are getting information from our sister government entities regarding a certain sectors or consumer bodies, or tips even from staff members. And when we talk about staff members, one of the investigations that was a success was actually from a tip from a staff member.
Tell us about that.
I may not go into the specific because it's still a lot, but it is in the steel industry. So a staff member was purchasing some product. He was constructing his house somewhere and he was purchasing his product, and then he got the information from a distributor. So because of that, then the authority was able to screen, and it's one of the investigations that is now subject to various appeals and settlement proceedings.
Thank you so much, Priska, for sharing. And of course, we have seen in the news a little bit about that. The telecoms industry, the brewery industry, if I can call it that. We've seen thing in the news over the past few years about anti-competitive behavior. So thank you so much for sharing. And just to our audience, if you have seen something that you classify as uncompetitive behavior, what is that? Could you share with us in the comments as a tweet, and then we can get to discuss a little bit more about it as we go along. Priska, I'll just come back to you from an enforcement and action perspective. Walk us through the step-by-step process from suspicion to busting a cartel to the penalties. What exactly happens and how does it happen?
An investigation process starts through a screening exercise or through receiving of information from a complainant. So initially, it will go through a stage that is known as a preliminary investigation process. So during the preliminary investigation process, the authority is satisfying itself that it has the jurisdiction over the allegations before it. So we're also satisfying ourselves that the information that we are having is enough for us to initiate an investigation. And at that particular point, if we find that perhaps it's not within our jurisdiction, the investigation would be terminated at that particular point and or may be referred to the relevant government entity. But when it passes that stage, then it goes to the next stage, which is called the full investigation. And at the full investigation stage, the authority has two options to do. One, depending on the nature of the investigation, it may issue a notice of investigation, whereby we are just telling the parties that the authority has reason to believe that you are contravening the act and these specific provisions of the act, and we want you to either appear before the authority to answer to certain question or supply us with certain information. So that one is done through information request or issuance of the notices of investigation. The other alternative that we have there is just to go straight and enter and search the premises of the parties. So the authority has the powers to enter and search. Obviously, we follow the due process. We ordinarily apply for search warrants through the courts. And once we get the search warrants, then we'll set up a team of investigators, and they will be officially be appointed as investigators because that's what the act says. And then on a particular day, then we'll just wake up and just surprise parties and get the investigation. So once we've gotten the information, either through the search and seize process or through the information request, we would go to the next stage, which is the stage involving analysis. We will analyze the information, and if we need to get further information, then we would request that information from the parties, or if you want them to appear, then we'll invite them for a sort of a formal interviews whereby we will show them the list of documents or the information that we have them and ask them to shed more light on that information. Then after that, then if the authority is satisfied at that particular stage, again, it will terminate the investigation. But if there's need to proceed, we'll go to the next stage, which is the issuance of a notice of proposed decision. A notice of proposed decision is a charge sheet where all the offenses are laid out and the parties are given even the evidences that is being relied upon by the authority to make the proposed decision. At that point, they'll be given an opportunity to make their submissions and try and kujitetea in balance on whatever the authority is alleging. Then after that, then we'll proceed. If there's need be, then we'll do even formal oral hearings. So they'll come with their legal representatives. If they want to represent themselves, then they're free to do that. And the authority is required at that stage to take into account all the written and oral submissions that will have been made by the parties. Then a recommendation will be made to the board of the authority on whether to make a determination. So the board will sit and convene at a particular time, review all the information that has been submitted by the investigators, and make their own independent decision as to whether to take up the recommendations being provided to them.
Thank you so much, Priska. So we've got a couple of comments already coming on, and I just want to put in this as we go into the next question, where somebody's asking, is it that CAK goes to the smaller businesses? Because, and he mentions, and I might not mention it as a company, but he mentions companies that are politically affiliated or were politically affiliated in the milk industry and other industries. And he says, why is CAK ignoring some of that and moving to taking action on small businesses? And I guess I'm asking, what's the price of collusion? What are the penalties for companies caught fixing prices or rigging bids or other such anti-competitive conduct? And I'd like you to keep in mind the question that one of our listeners has put in terms of who are these people you go for? The question is, don't you go after the big boys? And then is there enough deterrent to ensure that people stay to the code of conduct as a business?
Tyrion, that's an interesting question. Obviously, we do not discriminate. Any party that is brought before the authority would be investigated in the same measure. And a good example in the steel industry, when you look at the guys that we've investigated in that particular industry, these are not your ordinary SMEs, so to speak. So in terms of discrimination, I don't think we do that. We investigate whether you are the Kalu Works or whether you are manufacturing a sufuria somewhere in Mombasa. or you are playing with the big boys, when you contravene the act, then it will be applied effectively. In terms of the sanction, the act allows us to provide, there are two avenues for the sanction. One is the criminal angle, and the criminal angle, it provides that upon conviction, then there'll be an imprisonment for not less than 5 years or a fine not exceeding to 10 million or both. But that is the criminal angle, and obviously that is within the mandate of the Director of Public Prosecution. But what the authority does is the administrative remedies, which include financial penalties, and these financial penalties can go up to 10% of the preceding year gross turnover. So you can imagine if your turnover is in billions and we are going for 10%, then that is a very huge amount, right? Other than that, the authority also issues orders for cease and desist. So we can just also, in addition to financial penalties, we can also issue other orders like cease and desist, or we can mandate them to have compliance programs in place. Also, other than that, when we have the 10%, the authority does also take into consideration various mitigating and aggravating factors. For example, if it's a first-time offender, then that would be considered as a mitigating factors, because the idea is also to strike a balance between businesses to thrive and regulation. So there's a balance of regulation and also creating an environment for businesses to thrive. So the authority looks at case-to-case basis. In terms of it being deterrent enough, I think it is deterrent enough, because 10%, remember, it is a percentage of a gross turnover. So even though your gross annual turnover for the preceding year, so it covers your size and also it covers the impact of what that harm would have done or is likely to have done to the consumers.
Priska, I'm just looking at some of the comments and I'm laughing about one of them that says how Kenyans access government tenders and say ni God. And perhaps, Mokaya, we need a meme. We need a ni God meme. Kaya, over to you on that one. Lo has a question that Priska I'd like to pose to you at this moment. And she says, thank you, Priska. Are you able to share details on some of the searches and seizures and she says dawn raids that you have conducted? Perhaps you can share with us before we move to the next question.
Yes, so we've done a number of down raids. So one of the earliest down raids was in the cement industry. Around 2016, we did a down raid in the paints industry. How this investigation came about was there was a government directive that school buses should be painted yellow. If you remember, sometime in 2016, it was, I think, by the Ministry of Education. And because of that, there was a public outcry regarding the automotive paint industry. So we did screen the sector at that particular point, and our main focus was basically on the automotive paints. But when screening the sectors, we did to the field and we interviewed a number of people. We did a country-wide survey, and the investigation now was enlarged now from automotive paints to the entire paint industry, because we were able to find certain indicators to do with discounts, certain indicators to do with transportation costs, agreements, and pricing, and so on. After analysis of the investigation, the authority made a decision to invoke its powers under Section 32 of the Act, and we entered and searched the premises of 4 paints manufacturers. As a result of that investigation, a total of 66 million was imposed upon the paint manufacturers. The most recent one is the one that we did under the steel industry. The steel industry, it was one of our staff members who raised the alarm after he was doing his own purchases here and there. And we did also follow the same investigation process. And also in this particular investigation, we did an entry and search exercise. And this, we had a penalty of about 336 million that were imposed upon 14 steel manufacturers. There is also search and seizure, a seize exercise that had been done earlier on the fertilizer sector. So although for this particular sector, nothing much was gotten at that particular point. So those are some of the investigations that we've done through the entrance search.
Priska, how can ordinary citizens, myself and our listeners this evening, spot the signs of cartel activity? And most importantly, how can we report this?
Okay. So spotting the signs of cartel activities, this could be things, for example, you're a distributor and you're being given a price list by the manufacturers that it speaks to same constant prices, right? For example, in one of the sectors that we had investigated, the distributors only had to use one price list because it never made sense for them to stock price lists for all these other companies because this price list looked exactly the same. So that is one of the uniformity of pricing. And unexplained price increment or similarity into the price revision or the margin. For example, if you're being extended discounts, it is exactly the same discounts. It doesn't explain why a small company somewhere in Kilifi should be having the same cost of pricing compared to a company that is employing millions and millions of people, say, in Nairobi. One of the major indicators is usually on the pricing, but sometimes there's even more innovative ways that deal even with things to do with this or even product scarcity. In terms of reporting, we have the informant reward scheme, which individuals can take advantage of and give us credible information, and then the authority will be able to, reward them. So that is one of the very good tools that we want to put in place in terms of detection. Otherwise, just normal reporting mechanism through our channels, social media platforms, or even walking to our offices and reporting or raising complaints is one of the ways that the public can help us in the investigation process.
Priska, before I move on to the next question, I've got a very interesting question from Anna Konuche, and she says, seeing as the authority has a lot of power in respect to uncompetitive behavior by institutions, my question is what checks exist to ensure that the authority itself does not become a cartel in and of itself?
We work within the confines of the law. We are guided by the Constitution being the supreme law. Other than that, the Competition Act itself lays down the procedure of an investigation, which we must adhere to the letter. Then we have the Fair Administrative Actions Act, which we also follow to the letter to ensure that we're also giving the parties that appear before us adequate opportunities for them to present their case of a right to be heard. So the procedures of natural justice are usually followed. Other than that, there's also a recall. Once the authority has made its decision and the parties are not satisfied with the decision that has been made by the authority, we have the competition tribunal, and the parties have a right of a first appeal at the tribunal where the matter won't be relooked afresh. And even that instances where the tribunal has the powers to even depart from or vary the decision that has been made by the authority. There is also an additional appeal at the High Court. So I think there's a lot of mechanisms that have been placed within the law itself that ensure that the authority does not abuse its powers.
All right. Thank you so much for that. And of course, there's some really interesting comments that are on our Twitter threads. And to our audience, please continue to share that on Twitter using the hashtag Mwango Spaces. And our team from the Competition Authority of Kenya will be responding to them. And we will also be retweeting. That's from my handle and also from the Mwango Capital handle as well. I see we've just got about 10 minutes to wind up our conversation this evening. Prisk, we live in a tech-savvy world. So does the reality of commerce being conducted on the digital space make it harder for CAK to catch cartels? And perhaps you can tell us just with that, what other obstacles do you face as investigators? CAK.
And indeed, cartel members are coming up with a very innovative way to operate cartel tendencies. For example, right now, cartel members do not really need to meet in a room to discuss or even have something written or even leaving paper trails behind. For example, there's this aspect that is known as algorithmic collusion, whereby machines are being taught to learn the behaviors of their competitors, and over time, they're able to even collude. So the collusion is done by the machines themselves without even minimal human intervention. So these are some of the ways in which even the type of evidences that we are getting is not the normal traditional evidences, but evidence that is digital in nature. And because of that, then the authority has to innovate and look at ways in which it can also be at par. We are looking at evolving with technologies, just being one step ahead of the cartel members. For example, they're thinking about AI. We are also within that particular space, either by introducing regulation or introducing investigation techniques and strategies to detect such kind of conduct. The other limitations we do have, it's because of the lack of sufficient information, because cartel operate in a very clandestine manner, and they are based basically on mutual trust. There will be a member of a community or a member of an association, and the advantages that they gain or derive from that are more than them cheating on that cartel. And because of that, then we are coming up with these strategies like the informant reward scheme and the leniency products, which we are hoping to sensitize the members of the public and even the cartel members themselves to take advantage of these programs. And hopefully we'll be able to detect the cartels.
Priska, tell me, what advice does CAK have for businesses to ensure they don't accidentally engage in anti-competitive behavior? And you did mention some of the industries that are prone to it. Perhaps you can just speak to some of the businesses, maybe smaller, maybe startups, that could find themselves caught up in situations that they may not have planned to be in, but because they're the smaller players, they just find themselves in those spaces.
As the saying goes, that ignorance of the law is not a defense. So some of the strategies that businesses can employ is for ensuring that they have, one, a competition compliance policies within their programs, so that within the boarding package, when you're onboarding your staff members, you're also informing them or training them constantly on competition law and policy. They can also seek advisory opinions when there is a gray area to the authority, which we are happy to provide at free of cost at any given point of time. So the authority is open to advise and give advisory opinion. Does it relate to an agreement that they are not clear whether it's going to infringe the law? Then they can approach the authority on the basis of advisory opinion. They can also engage experts, lawyers, and when they're doing their legal audit, then competition enforcement can be introduced as an aspect of the legal compliance, which experts right now can look at their policies and ensure that they comply with the law. They can seek for exemption within the authority. For example, if they have good reason to believe that engaging in that practice is likely to give the public more public interest benefits than the lessening of competition, then the law itself gives some framework where the parties can approach it for an exemption, and that will be allowed. They will be allowed to engage legally in that practice. Obviously, they can conduct self-assessment, and if they think they fall within the scope of the block exemption guidelines that are provided already by the law, then they can then proceed to engage in the practices within the framework of the block exemption. Yes. Obviously, take advantage of the leniency program and the informant reward scheme.
All right. Thank you so much, Priska. And I just want us to make a bit of a comparative to the global perspective. And perhaps you can tell us, how does cartel enforcement in Kenya compare to other countries? Are there lessons we can learn from international efforts? And I'd like you to respond to that. And I'd also like to rope Mugambi back into the conversation as we wind up. But Priska, let's start with you.
In the East African community, I think Kenya is ahead in terms of competition enforcement. Our neighbors here, Uganda, have recently enacted the act. We are looking forward to see the jurisprudence that will emanate from the application of their law. But regionally, we do benchmark a lot with South Africa. We have exchange programs with them. We have joint capacity building initiatives. We have staff exchange programs with South Africa, a collaboration framework whereby we are able to exchange information relating to particular sector. Then we also have in the regional space, we have the COMESA Competition Authority who are making good efforts in competition enforcement and all that. We are able to borrow from their good practices in the precedences they are setting in the enforcement of the cartel. Globally, we look at the UK mostly and the EU, and that's mainly because our law is very similar to their law, and unlike the US. Internationally, we borrow a lot from the UK and the US. For example, right now, they're having the Digital Market Act that has recently been enacted, and the authority is also looking into ensuring that we have that in our amendments that we are proposing.
All right. Thank you so much, Priska. Mugambi?
Thank you. I was also learning quite a bit from my colleague Priska. In terms of the global space, as she said, we mostly align ourselves with the EU. For instance, cartel enforcement is not a new thing. It's been there for so many years, from way over 100 years. I think just yesterday in Italy, I saw the competition agency there raided some big companies. They are well known. Novartis, there's another one called Biogen. They think there was a collusion. They wanted to delay delivery of eye medication into the country so that they can remain competitive. That's the allegation that I think came out yesterday. In December 2023, Malaysia, there was a chicken feed cartel between 5 companies. They raised prices. Again, closer home in Egypt, I think last year in Feb, there was the poles, the lampposts that in the street, they had colluded in terms of bid rigging, which also speaks to the question that we'd been asked. Cartel enforcement is not new. As Priska has well elaborated, what we can do is that since the enforcement in those jurisdictions has been there for quite a while, we draw our lessons from them. We are members of ICN, as has been mentioned. ICN is an international network that has majority of these big boys, so to speak, our elders when it comes to enforcement of competition law. So we don't reinvent the wheel sometimes so much in terms of where the trends are going. We can see them already. As Priska has mentioned earlier in the conversation, we have current support in terms of forensics training, the hands-on knowledge, but also the equipment. We are upgrading our system. We don't rely on others so much. The assistance is coming from all over America. There are some partners from OECD. There's a lot of partnerships and being brought up to speed so that when new things are happening in cartel enforcement, we are not left behind. And the new things that you'll see, digital, basically what you're learning from what they're doing and also coming to tailor make them for home. It's not a copy and paste sort of a regime. We see what is happening, then we'll tailor make the solutions, the laws for ourselves. So things in digital markets, we are seeing a lot of cross-border cartels. Now we have to answer how the EU and other places do it. What happens if we detect a cartel has crossed the border into Tanzania, that the companies are in 5 jurisdictions? So we have ongoing engagements with the Competition Commission. IACA is the regional body. Priska has mentioned Uganda's law, a bill, has long been a bill, is now a law. So even locally, a lot of enforcement power is coming to us. The last thing is data forensics, that machine learning cartels, the new thing. People don't leave notes, don't write. You may go and rate people and you won't find notepads or price lists strewn around their offices. But if you dig deep into their laptops, into their phone, you get evidence that the cartel is existing. So I think that's how we compare. Terry?
Mugambi, both to you and Priska, we've got a question from Dr. Shad Katu, and he says, without revealing sensitivities, and he says in brackets, methods and sources, what lessons can be drawn from the forensic activities undertaken by the authority?
I'll take that. The lessons that we are learning is that we need to constantly upgrade our forensics, right? Because you see, you might find the software that we've acquired right now, perhaps it can mine a certain version of a phone, and perhaps the manufacturer has upgraded certain things in the next update or the next iPhone or whatever particular phone that they, and perhaps now our softwares are not sufficiently mine the data. So it is just being up to date on what is happening within the forensic world and ensuring that our softwares and our equipment is up to date and what is currently provided for in the market, because what we are using today may not be useful tomorrow.
All right. Thank you so much, Priska. We're coming to the end of our conversation. I'd like to hand it to Mugambi to give us some final remarks, maybe some things that have stood out for you before we proceed.
Thank you very much, Terian. Also, Eric and our main speaker, Priska. My takeaway is that cartels are not beneficial to you and I as consumers. Some people will say that businesses in cartels, the people behind them are just thieves in suits. So they basically look like they've made it and big business, but at the core of their success, perhaps is not right, is not competitive. They're not allowing other people to thrive in the market. So as we had mentioned, that why cartels are bad is that where they're allowed to thrive is that prices in particular. The other things that Priska has mentioned, there's no innovation, your access to choice is limited, investment don't come in. But the main issue is that prices go up. CAK's mandate is not to set a price and to say that the price of this commodity should be this. No, that would be anti what we stand by. But you will find that where cartel exists, the prices typically up to that 5% more than they should be. Back in the day, I think maybe 6 years ago, we did some work in the cement sector. We also did, as Priska has mentioned, a few years back, we did some work in the steel sector that ended up with a 66 million penalty being penalized on the big players in that sector. So for instance, in the cement sector, once we came back and did our analysis, we had saved consumers up to 2.3 billion Kenya shillings. When in the paint sector, we had saved consumers up to 930 million Kenya shillings. Don't ask me the specifics of how these amounts are arrived at. They are done by our research team, go to the market, they have their way of drawing the data from the sector, the specific sectors, the consumers, and then they make and they draw these conclusions. So as you can see, the benefit to a consumer is there. It exists. The harm, if we don't do anything in terms of CAK, is real. And lastly, as you said, there was a comment about public sector procurement. I've seen another comment which I cannot repeat, but it's there. Majority, it's 40% of government budget goes to procurement. Okay, so if we allow bid rigging to continue, there are things we are working with, maybe with the PPRA. You can critique maybe the speed of it, but it's there. We are trying to ensure that people don't bid rig, people don't do cover bidding, they don't segregate that anything that goes to this side is mine, another one that goes this side is mine. So there's some work which is going on. If you have information, evidence regarding this, we've done some work in the polls in terms of public procurement. It involved REREC. So I'm not just saying that these are aspirations. There's evidence of work that we have done, penalized some entities and concluded cases, even in government procurement. So I think with that, for me, just to thank you, tell you that you can go to our website, www.cak.go.ke. If you go to the publication section, you'll get a ton of information about the work we do, specifically what Priska has talked about. You can call us, +254 20 277 9000. You can walk into our offices. We are at CBK Pension Towers. It's in between the Deputy President's office and the National Police HQ. So the new building there, 15th floor, you can come and see us if you have some information you want to give us. And lastly, it would be remiss of me to end without indicating to our listeners that on 14th and to 16th of October, we have an annual training every year. This information is disseminated as wide as possible through various channels. If you go to our Twitter page, I think the 5th post from the top, you'll get more details about the training, various topics including cartels, 14th to 16th this year, October. Then we'll finalize with a symposium on 17th and 18th of October 2024. So you're all welcome. The details are on our page. Thank you very much to Mokaya, TC, and Priska for the engaging discussion. Thank you.
Thank you so much, all of you, for joining us on Spaces this evening. Once again, very informative discussion. Priska, thank you so much for the detailed information. Then Mugambi, always a pleasure hosting you. We'll hope to have you again. Thank you once again for joining us today. See you next week for another edition of Mango Spaces. Mugambi and Priska, maybe you can say bye as we close the Spaces.
Thank you very much, Eric, and the team from Mwango Spaces, Tyrian, for being a nice host, and all my colleagues for joining, and all the listeners. It's been a pleasure sharing my experiences and the experience of the authority. Let's continue engaging. Thank you.
Mugambi?
I think I spent my closing remark. Thank you all to all the listeners who've joined in. It's always a pleasure engaging you. And as I've said, for more information, go to our website, www.ak.go.ke, for more information regarding what we do, how to engage us, and everything in between. Thank you very much to the host, the moderator, Terian,